My next guest is Peter Myerson from Cohn, Rasnick, Myerson, and Plout. Welcome, Peter.
Well, thank you, Jeffrey. It's great to be here.
Thank you. You have a story for us today, correct?
I do, but before I get into the story, which is about jointly owned intellectual property, I do want to remind the audience that the Massachusetts Senate came out with a bill which is going to effectively gut non-compete agreements. So we've all been expecting it. The legislation hasn't quite passed, but the change has been that Governor Patrick has finally decided to promote the legislation. And this is actually what came out of the Senate is actually a cut-down version of what he wanted, which was effectively the California statute, which basically, does away with non-competes altogether. So I think this is more in the category of, listeners beware of what's coming because it's coming. What I'd like to talk about is something which I've talked about before, but which I think really needs to be elaborated on to some extent. And that is the issue of ownership of intellectual property. So I have talked about it in the context of, you hire an employee, if you don't have an agreement with them as to the ownership of who owns the intellectual property that he develops, there's a real question about who owns it. And, typically if you hire somebody to do intellectual property, there may be some common law ownership via the common law, but it's risky and it really becomes an issue of what happens if you sell your business, because the venture capitalists and the investment bankers, before they allow you to sell your company or put money in, are definitely going to want to know that you own what you say you own. So, where you thought that the joint ownership would solve you a problem at the beginning, what it's turned out to be is a catastrophe at the back end. And it's the kind of thing that really people, don't think about. And there are ways to solve it. Solving it involves paying a lawyer who knows what they're doing to kind of help you with this process and figuring out what it is you want to do with your business and evaluating the risks of all this. So, you get somebody who kind of helps you figure out how you determine what fields are what and who controls them. And if you can't do that, there's kind of a backup, and you take the example I gave you, one company going to another company. Suppose you have 3 or 4 people playing in the, with this intellectual property. You have 3 or 4 players. So you can see how this rapidly becomes a problem of huge magnitude. So, you can create a patent pool,
right,
where you engage an independent administrator. I mean, again, you have to worry about your costs, and you have to sort of evaluate, what you're trying to achieve with your business. But you can solve the problem with with what's called a patent pool. And, you just say anything that's developed by the 4 of us or the 2 of us, is going to be administered by, Harry, who's a professional, typically a technocrat. Or Harry will determine, instead of us trying to decide what fields there are, and which of our fields is closest to the product that's developed, Harry will make that determination. So Harry, who's the professional, will say, okay, this improvement goes to X company, this improvement goes to Y company. But, I think the important takeaway from, this, issue is that it is hugely risky to have jointly owned intellectual property when you're a company.